Well, welcome to the final session. We have a wonderful panel lined up. I'm going to introduce the speakers one by one, but we've all agreed to save questions to the end to maximize the amount of question time. So my first speaker is Nancy Kim, California Western School of Law, where she's a professor. She's the author of a very important forthcoming book called WRAP Contracts, Mass Consumer Contracts in an Information Society. And if there's anybody left that doesn't know what WRAP Contracts refers to, it's the online contracts and contracts for software, I assume you cover, yeah. So near and dear to my heart, being also a contracts person. And she also has extensive business experience, having been Vice President of Business and Legal Affairs for Exogen Group, among various other activities. So we're very fortunate to have her to comment on privacy.
Thank you. The title of this panel is What is the Right Legal Regime? And this is a large, complex problem, the problem of privacy and technology. And it's going to require more than one type of legal response. We're going to need a variety of legal responses, a variety of solutions, in the same way that we need a variety of solutions to deal with the problem of poverty or crime. We absolutely need legislation, although I'm going to spend most of my time talking about non-legislative responses. We need legislation. We need an omnibus privacy protection bill. We need legislation governing the use of data. We need there to be legislation that requires that all consent be an opt-in as opposed to an opt-out. And there should be a notice requirement with respect to geolocation technologies so that there is no stealth tracking. It's not really clear that there's a legitimate business purpose to those technologies. But again, that's a lot of legislation. I don't really want to spend a lot of time on that. And the reason is legislation is not going to be enough. It's not enough because the legislative process moves too slowly. And because legislation has to be so detailed, it's never going to catch up with these technologies. Another way companies have traditionally been regulated in this country has been through tort law. One of the goals of tort law is to deter undesirable behavior. Tort law is standards-based, so it's flexible enough to accommodate a dynamic environment. But for the most part, tort liability or tort-based standards haven't been imposed on code companies. And by code companies, I mean software, internet, and mobile computing app developers as well, companies. And the question is, why do we treat these companies differently? We tend to treat these companies differently, I think, because I think we're a little awed by them. We tend to forget or confuse the fact that they're profit-making companies, private companies, and we sort of make them stand for other things like protectors of free speech or innovation with a capital I or American capitalism at its best or genius computer geeks, okay? The intangibility of information, of what these code companies do, also makes it difficult for us to look at them like regular businesses. Do they provide a product or a service? If they're providing a product or a service, why aren't we paying for it, right? Are they licensing? Are they selling? I mean, what is it that they're doing? And so we can't really put them in this pre-existing, or they don't really fit into our pre-existing notion of what businesses do. But if we accept that privacy and personal information has value, we should accept that when it's been used, this information has been used without our consent to enrich someone else, then something of value has been taken from us. And when it's used to create a product that harms us, then we should recognize that the product or the service may be defective and treat it accordingly. Now, geolocation apps and these devices are great tools in a lot of ways, but there are some predictable dangers associated with them. The companies that use them and build upon them should anticipate these dangers and build safeguards into their offerings. Now, I want to talk about one particular danger because I think we can only talk about one particular danger at a time, because I think one of the problems with talking about privacy is that it's a big blanket term. It covers a lot of things. It's like talking about crime. What type of crime are you talking about? It matters, right? So I want to focus on one particular danger here, which is associated with geolocation services. And it's a danger that has probably occurred to many of the women in this room. And I can almost guarantee that it's occurred to every woman who has ever been in an abusive relationship. And it's the use of these devices in stalking. Now, I was dismayed and greatly saddened in the course of doing research in this area to find out how often tracking devices have been used in battering, domestic violence, and abuse relationship type cases. And the question is, why haven't safeguards been built into these services? And I think there are two primary reasons. The first is that's not where the money is. Finding out where you live and selling that information, learning how to monetize it, is worth a lot more money to these companies than a woman's peace of mind or safety. The second reason is that maybe the developers don't have the same concerns. They don't care. They're not thinking about it. It's not something that's on their list of things that they think are cool to think about when they're thinking about developing this app or this tool. And maybe they need to start thinking about it. Maybe they need some incentive to start thinking about it, like the threat of a lawsuit. Now, companies are in the best position to prevent harm. Now, this is just an example of a company. This sort of advertising that their software can be used in finding your cheating spouse. Just in case some of you aren't aware of some of the type of technology that's out there, you can basically download or upload install on someone's smartphone in a matter of seconds software that can not only track them, but can take screenshots of their emails and what they're watching. And companies sort of tout that. And you think it hasn't occurred to you that if you are advertising the use of this product to catch your cheating spouse, hasn't it occurred to you that the person who's buying that, they might be possibly an abusive partner? That they might be using this for a criminal purpose? Okay. So companies are in the best position to prevent harm that arises from these products and services, from their products, the products that they put out there and services. For example, they can do a better job of testing these products and services before they release them to the public. That's what other companies do. They test it. They don't just release the product and then wait for consumer groups to come back at them and say, hey, wait a second, you're violating X, Y, and Z laws, right? They usually test it first. There are a lot of things companies can do. They can install, and again, I don't want to spend a whole lot of time on sort of the things, the improvements that companies can make to their products, because it will depend on the type of product. But as a general matter, when a device or person is being tracked, some companies send a text, some don't, right? You can have a light that goes off. Now, if the tracking is for legitimate purposes, like let's say your kid is going off camping, they know they're being tracked, they're happy for it. So the little light is not going to be a problem, okay? There should also be other ways to sort of modify products. There can be a sound that goes off, there can be location blocking. Companies should also have some internal procedures. They should not be surprised that when they are advertising their products to catch a cheating spouse, that the product might be used to stalk or terrorize a partner that one thinks is cheating or not, or just to have some control over. And so companies should have some internal policies. How are they going to deal with that when somebody calls them and says, look, my crazy ex is, I'm pretty sure that they've installed something on my phone, or that they're tracking me. And they should have some procedures, some sort of internal mechanism, corporate policy in place to deal with it, not act like they've never heard of this problem before, because it's not an uncommon problem. In fact, it's a very common problem. Now, I'm going to be spending the rest of my time talking about the last two measures, which is educating users and using contracts to protect users. Now, I want to focus on a specific harm, because otherwise the conversation gets a little too unruly. And it's a foreseeable harm, which is the use of geolocation devices in stalking or to harm or to commit sort of a criminal act. Which brings me to an app that Lori had referred to earlier, which is Girls Around Me. Now, Girls Around Me is a geolocation-based maps app. You push a button, okay, and then the map fills up with pictures of girls who are around you, who have checked in with Foursquare. Okay. Now, you can then tap on a particular girl's picture, and you can get information that was pulled from her Facebook page. Okay. Now, when this sort of stalking or sort of uncomfortable, creepy sort of possibilities raised alarm bells in the blogosphere, the app maker issued the statement. Okay. And basically what he said was, hey, it's not my fault. We're just using data that was publicly available, and the purpose of our app isn't to enable stalking, it's just to help people find out where to go, hang out in the city, find people with common interests, so forth. But, you know, their website advertisement is a little different, right? Make it clear that they want you to use it to find lovely ladies, okay? Which might not be a problem if those lovely ladies wanted to be found, if they understood this is what might happen. And just to give you an idea of why, in case some of you are not as devious, okay, as someone who might download this app, what you could do is you could go to a bar, okay, and you could see somebody, you want to find out, you know, girls around me, what girls are around me. And you see, oh, she's sitting right across from me on the bar stool. And you find out some information. You find out that she has a brother that went to X college. And you say, hey, aren't you so-and-so's brother? And she says, yeah, no, I was his roommate's buddy. We met before. You know, you can kind of do all sorts of manipulative, scary things, right? When you have information about somebody and they don't know you have information about them, okay? So that was the problem. So I don't actually want to focus on iFree, the app developer, because they're sort of, you know, you kind of know what they're all about. They didn't claim they didn't see it this way, and I believe they didn't see it that way because they've probably never been stalked. They didn't look at it from the other perspective. Okay, but I want to focus on something this company said, which is that they were just pulling data from publicly available sources. That's all they were doing. Okay, it was already out there. Now, the problem's complicated because of the way data is aggregated. And, even scarier, think of the possibilities, because of the way different technologies are aggregated or can be combined. So imagine your Facebook content with facial recognition software and geolocation, right? So the possibilities are, and not only that, then your offline purchases at the drugstore. Facebook just partnered with a company that possibly can, they're sort of, it's unclear what exactly they can do, but they work with loyalty card programs at drugstores. So Facebook could possibly access your whatever purchases you made at the drugstore. Think of all the things you bought at the drugstore. Sure, you say, I'm not ashamed, but that doesn't necessarily mean you want your grandparents to know what you just bought or your kids, right? Okay, not that it's illegal, but again, we were talking about privacy issues. So the problem's complicated because of the way data is aggregated and because we don't know, and I don't think these companies know yet what they can do with the combination of technologies. So I think we need to start with how data is aggregated from, for example, a social networking site like Facebook. Okay, some of you might think, it's not really Facebook's fault, is it? I mean, they can't really control another company. They can't really control what iFree does, right? Or how a consumer uses their product. And the answer is, yes, they can, and they do all the time. And they do it with something called a contract. Now, before you roll your eyes, consider this. Every business on the internet, I think almost every business, if not every business on the internet, uses a contract to bind its users. And if you don't think that they're enforceable or that they're effective, then just try to sue one that contains a mandatory arbitration clause. Okay. We think of contracts as a big joke because companies have gone crazy with them. They use them all the time. But they haven't gone crazy with them in a way that benefits users. They've only used it in a one-sided manner to protect themselves, not their users. And they can do better. They can use contracts in the same way that other businesses, brick and mortar stores, for example, use notices. They can use contracts to warn their users of possible dangers. They can use contracts to inform and educate their users of their policies, for example. And they can also use contracts to limit their liability, to draw boundaries around their own tort liability. Okay. Now you might think notices, contracts, nobody reads contracts, right? Well, that's true now. And it's because of the way contracts are currently presented on websites. A recent study showed that using an eye tracking device, that very few people read nutrition labels unless the labels did not require turning the box, in which case more people read the labels, like when they were on the front of the package. Some other researchers came up with privacy policies, but they put them in a label form, okay? And it really enhanced the ability of participants to find relevant information. We had talked earlier today about privacy policies and the fact that people say one thing, but they don't really read the policies because they don't understand them, because of the way they're presented, because of the language that's used and the way that they're formatted. Okay. Another study showed that textured agreements significantly increased reading time and retention. Textured agreements are where you have some sort of visual variety. Okay, I think I'm going to have to speed this along. So this is an example of textured agreements where you have bubbles and so forth. I want us to look at what Facebook does. Okay. When you get to Facebook's homepage, what do you see? What do they want you to do? They want you to download some apps, right? They want you also to sign up if you're one of the 2 people on the planet who haven't, okay? Do they want you to read the terms? And the answer is no, okay? Because let's say, though, you wanted to know, how is Facebook going to use my personal information? Let's say that you clicked on the terms hyperlink. It would take you to this page, which still doesn't tell you how they're going to use your data, how they're going to use your information. For that, you have to click on yet another hyperlink, which takes you to this page. And then you've got to click on the first hyperlink, information we receive and how it's used. And you have to scroll down. I didn't put all the screenshots up here because I got tired of it, but you have to scroll down about 7 times. And then you finally find out how we use the information we receive. And even then, the wording is not very clear. Okay, what could they do? They could warn you, okay, when you get to the website, the way that when you do something, when you use other products, they have warning labels. But you don't think of Facebook as a dangerous place. They could also require you to opt in. Now you think, what is this? You don't want to click, 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 click. That is such a hassle, right? And the idea is, yes, that's right. And safety generally is a hassle. It's a hassle to wear a seatbelt. It's a hassle to wear a helmet. There's another sneakier reason I think that there should be an opt-in. It would require Facebook and other companies to really think about how they use your personal information. Is it really worth the loss of goodwill in having you click? Maybe they draft the policies in a more understandable manner. Another thing you could do is have them actually type some consent and email it in to the company. Another thing companies can do is they currently require their users to indemnify them in the event they do something. So Foursquare, for example, has an indemnification provision contract with iFree. Only iFree probably didn't know that. Okay. Maybe they should have driven that point home. And the whole idea of these types of contracts, presenting them this way, is to break the cycle of habituation, this constant clicking that doesn't register in our head as far as what it is that we're doing. So we're not even conscious of sort of the dangers associated with releasing personal information or of or violating user codes of conduct. Okay. Now, because I'm running out of time, I just want to quickly sort of wrap up that some companies are being a little more responsible as far as the dangers that their products pose. AT&T, for example, is mounting this big awareness campaign about the dangers of texting and driving, okay? Because, yeah, it's not their problem per se, but people are using their technology and in a dangerous way, and they want to raise awareness. Don't do it, even though they make more money when people text and drive, right? Because the more time, when people are texting all the time, they make more money. Other companies, though, they don't really want to warn their customers of the dangers of their product, and they resist all types of labeling. They're really fighting hard. And the question is, why don't we treat these code companies according to the way they act? Because the imposition of tort liability would require them to be responsible for their actions. And just as a final point, and because a picture is worth 1,000 words, I want to show you some images of some early tech startups. These are the folks who are dreaming up these business models. So you've got the founders of Foursquare, LinkedIn, Twitter, and Facebook. Now, all this is to say that it's a lot to ask of these mostly young, mostly men, to run a business and think about what's best for society at the same time. We expect that these folks have thought about the societal consequences of privacy spills or data misuse. But why should they? If we continue to treat them not like they're profit-maximizing companies, if we continue to trust them and not regulate them, then we're essentially letting these founders of these companies make important decisions for the rest of society. And when we finally realize what we've done and we regret it, it might be too late.
Our next speaker is David Stampley. He's a partner at Camber Law, and he has over 12 years of experience in consumer data protection and security issues, including most recently some flash cookie issues and some deep packet inspection by ISPs. He brings us an enormous wealth of experience from the practice world, and I would, without further ado, let him speak for himself.
I'm Dave Stampley. I hope I did not seem impolite during the last speaker and others if I was tapping on my computer, but I needed to make some notes, otherwise I would have nothing left to say because the ground has been very well covered. I'm only part kidding. At least I may say it differently, but and it's not the easiest thing for me speaking here because although I'm grateful for the invitation from thanks. They were so young and fresh and entrepreneurial. All right. Now, as I was saying, I'm usually asked to come to conferences, and I'll say to the conference organizer, what should I do? And they say, scare people. And the reason for that is very often it'd be an audience primarily composed of corporate lawyers, and in the past I've been a prosecutor, now I'm a class action lawyer. But I guess I should count it as nice that Professors Warner and Andrews didn't ask me that, and Dean Krent, who used to scare me in con law class a number of years ago, didn't say that either. So I'm truly very, very happy and very honored to be here, especially given the speakers that I've already heard go before. But since a lot of material was covered, I really had to dig down into my memory banks to think of something relevant but not yet said. So I will tell you that, I'll go back for 1 second. I will tell you that when I was 12, my father was a career Army man, and we had some interesting assignments. In one of them, we were in a foreign country, and on several occasions, we were not on a post. We were actually living in the civilian community, and on this occasion, that was true. And there was a Russian consulate in the city, and we went to see an art exhibit. And I was 12, and I was still at that age where just writing your name was seemed exciting, and I saw a guest book, and so I went over to write my name, and I felt my father's hand on my shoulder, and he said, "Don't sign that guest book. You never know where that name will wind up," because this was still during the Cold War, and that really made an impression on me, and I don't know if I would have been as privacy conscious. And then, just to add to the paranoia, my my mother, if they had to go to some event that was international in flavor, would come back and always have a headache, and she would say, I know they're all spies, I know I have nothing to tell them, but it still really gives me a headache. So that was the environment I grew up in. And so here I am today, right? Now, the slide that you saw there, the name of that is Scene on Bear Creek, Woods on Fire, and from 1848. And it's a scene of a train on the Lehigh and Susquehanna Railroad as it's going through a forest southeast of Wilkes-Barre, Pennsylvania, and catching the forest on fire, because it was very common then for sparks and cinders from the early locomotives, especially that were still burning wood, to cause forest fires, and a lot of forest and farm acreage was burned. And maybe one lesson from that is sometimes a new technology can have unanticipated consequences. And sometimes those consequences are so pervasive, they're so global in scope, and they affect so many parts of society that society must make adjustments. And that might be in the form of rules like how far from a railroad track crops should be, and who's at fault if the cow doesn't just get gently lifted up on the cow catcher and survives, but instead dies, right? And so there's a loss of livestock. And sometimes the changes need to be to the technology itself, such as the installation of crossing guard gates and flashing lights, or in the case of, and I don't remember what year it was, in which trains collided and included a number of people who were attending, I think, the St. Louis Exposition. There was a horrible loss of life, and because I believe a signalman had fallen asleep and couldn't remember if he'd seen the number 2 train or the number 3 train go by, and it was before the days of automatic signaling. Or even Commodore Vanderbilt in New York, who finally submerged the part of the railroad near Grand Central Station because so many nice New York pedestrians were getting run over by the trains coming into Grand Central Station. There were also some collisions in that case. So a new technology can really change things enough that it shifts our worldview. And I don't think I would be disagreed with by people if I said the internet is definitely such a technology. But still, before we talk about the internet, let's talk about some other motivations for change. Now, many of you are probably familiar with the story of a 21-year-old actress named Rebecca Schaefer, who in 1989 was murdered by a stalker who was able to locate her because he paid a private detective who went to the California Department of Motor Vehicles and for a not too large sum of money was able to purchase her address, gave it to the assailant, who then knocked on her door and murdered her. And that led to the creation of Driver's Privacy Protection Acts. And I can tell you from personal experience, when I was a privacy officer at a company that used such data, at one point we were going to license some driver's license data from a data broker. And I dealt with this data broker before, and I remember being very frustrated because I would have to explain, no, when we ship the data to you to be cleansed or manipulated, it does need to be encrypted. It needs to go securely. These are customer databases. But when it came to that driver's license data, we sat down in a conference room and they said, you get this data for X number of days, then you have to promise to purge it and return the original tape to us. You must sign this statement that you're using it for these purposes. I was so happy that they were so dead serious about using this data properly. It was really gratifying. Now, some of the examples we've talked about today, perhaps that's not the case, and the issues are what legal regime might we promote to help make that happen. But so who's threatened? Typically, I'm dealing with consumers, and by what or whom and why, as I'll show you in a minute. I'm not here to talk about government surveillance, and I'm not here to talk about some of the truly fascinating transportation situations we've heard about. I'm talking about little old advertisements on the internet, and there's a lot of them, and they're doing a lot. So, and then, of course, the big question that I think one of the speakers this morning, I have a bone to pick with him because he basically said, we'll answer all those tough questions here in this panel about what the answers are, but we'll at least refine the questions a little bit more, maybe. Now, the technology we have is treated as a fait accompli. The internet that we have, the way the internet works, the way cookies work, the way when you go to a website the next website you visit can see your referrer URL, which I never can remember how many R's it has. They know what website you went to before, or your IP address is available, all kinds of user agent information. The way the web works, not just the internet, but the web, is a choice. And as a matter of fact, I believe it was Tim Berners-Lee who wanted referrer URLs to be available to the next site so that as a friendly gesture, if you have a website and you link to that site and someone clicks on the link, perhaps that website will return the favor. Well, that's not, what has happened with referrer URLs. They are a major way to track what you're doing. And a lot of this came to an important decision point in the late 80s, or maybe it was early 90s. So there were browser wars back then, and cookies had just barely come into existence. And the CEO of Netscape even told the FTC in I think it was 98, we know that the Internet Engineering Task Force is going to hand down standards for how cookies should work, including whether or not when the user is browsing, by default, third parties should be able to set cookies for tracking purposes, or whether or not that must be opt-in. We will do what the IETF says. They didn't. By the time the browser wars were in full swing, Netscape was allowing third-party cookies to be set by default. Microsoft's fairly new browser at the time was. And what's more, based on the history I've read, it appears that the advertising interests and the browser manufacturers pretty much tanked the IETF process and slowed down the development of the standard. And that was a key moment that led to the world that we have today on the internet. There was a lot of industry lobbying, and there still is. And then in 2001, the profession I'm in was blessed with the major event of the DoubleClick decision, which I'll have a couple comments about. But before I do that, so what is it that bothers us? This is not about geolocation, but the point that I want to make here is, especially in the early days of the internet, why did spam bother people? Besides that some of the messages hurt your feelings a little bit. But there was so much of it. It was a matter, I believe, of volume. If you only had gotten one spam message a day, would spam have seemed so bad? Probably not. And to AOL or to CompuServe or any of the dial-up services, it probably would not have seemed so bad to them either. But spam did, and to a large extent continues, to impose a huge cost burden on those companies, as well as a huge, I would argue, cost burden on consumers. And not only that, data breaches on, someone tell me, what's the name of the website that tracks them so well? The one that's has a chronology of data breach, Privacy Rights Clearinghouse, right? So they've been trying to track them, and a huge number of data breaches. Now here, you might or might not have been affected by identity theft, but you didn't know. You can see a train coming, but you cannot see a hack coming, and you may not even know when you're getting hacked. So what do we have? We have the misusers of the technology, and we're in the dark, we can't see them coming. And then we have the advertisers that had lobbied for third-party cookies to be accepted by default, meaning we can't see them coming either. So what we have here is deliberate obscurity, deliberate keeping of consumers in the dark. And look, folks, I am not a conspiracy theorist. It's true I don't have a Facebook account, but I do use a computer, excuse me, and but I just think that this is a historical fact. And I think there's a word for that. I like to use it because it's fancy, and that's information asymmetry. So I have a message here, and I'm going to say it with all due respect. I know lawyers particularly like to talk about balancing of interests and evaluation of theories that might help explain or resolve matters. Sometimes the baby can't be split. Sometimes it is unfair to say, let's do a cost-benefit analysis. sometimes it is premature to say, let's look at how we can resolve this, what mechanisms we can put in place. You cannot put mechanisms in place when you don't know what you need to put mechanisms in place for. You cannot put mechanisms in place when you're in the dark about what threat you are trying to address. And I guarantee you, you are in the dark. And I'll tell you what else. You've heard some comments right now about companies perhaps not even being aware of what data they have in their possession, what the power is. I think that's true. I think even the people who are keeping information from us also may not know exactly what they have their hands on. And I'll give one or two examples of that. So, an advertising power, but just what does DoubleClick do? We know some about it, but we still don't know the whole picture. And DoubleClick is certainly doing more now and has been acquired by Google, and now there are many other companies. There are about 10 at the time the DoubleClick decision came down, maybe 11. Now there are fewer than 300, but well over 200 third-party advertisers or quantitative analysis companies on the web. Now, I did hear a comment earlier about the money to be made on the web. Look, there's a lot of money to be made on the web, but a whole lot of tracking, including geo-targeting, is not the majority of dollars being generated on the web. So don't anybody call me a job killer. So this is a chart that indicates the extent to which the ad spend online proportionally is made up in certain platforms. It includes behavioral advertising. Now look, if you were to figure out by looking across the line how many millions of dollars that is, I'm not saying it's insignificant, but behavioral advertising, which is where tracking happens, is not driving the web. And the web will not die if it is modified to suit privacy needs. A lot of behavioral advertising takes place on what's called remnant inventory, the leftover real estate on web pages that couldn't be sold to the big companies that are advertising for the big football game, but to try to monetize in real time that space that's left. So we are not talking about the major driver of the industry here. But we are talking about a few dollars engaging in a lot of tracking. So whether you're talking about spam or you're talking about online advertising, what you see is that a tremendous effect, a tremendous volume of data is being taken consumers, prompted by a relatively low barrier to entry for the ones who are doing the taking. And in the process, one reason their barrier to entry is low is if there's poor security practices, that can be pushed off the consumer because courts are loath to impose liability on a company for a bug. They're getting a little better about it, but it's not easy for consumers to sue and recover even when they have lost significant dollars, even when they've had a keystroke logger installed and accounts wiped out. Now, there are all kinds of ways in which consumers are given good notices, like some that we saw a moment ago, your mortgage HUD statement or a stock prospectus or a street sign telling you where to call if your car is towed. But what do you think about the quality of notices you have on the web? I won't dwell on it because we just heard something about it. But let me tell you something. The companies that engage in third-party advertising are superb at logging exactly what you look at, when you look at it, you know, what marketing segment you fit into, reporting that to whichever advertiser they're supposed to get credit from, and in real time bidding against each other to say, all right, I can serve that ad for 2 cents. I can serve that ad to someone with this kind of cookie for 1.5 cents. That's happening in real time. They're communicating with each other extraordinarily well. It seems like they could communicate with the user. And I will offer one provocative way to do that in 4.7 minutes, according to this sign I just saw. Now I will give you just a very brief and speedy history of some of the evolution of tracking cases that I would think geo-targeting fit into. And I won't go through each one by one. I'm happy to answer questions about what these are. We have one deep packet inspection case still pending here in federal court in Chicago. That's Valentine versus Wide Open West. We have already been through our arbitration clause hearing in a post-concepcion analysis, and now we're back on solely a claim under the Electronic Communications Privacy Act, the Wiretap Act. So the one point I will make about these cases that you see listed here is a number of them arose from tracking, but also just from internal error and miscommunication. And I think this goes to a point that you heard a minute ago. And just to give you one quick example, where is it? Well, I didn't put the case name up there, but spyware, adware. The Eli Lilly case, Prozac.com case, I'm not sure which of these it is. I can't see through all my colors. The Prozac.com case, from what I understand, basically, it's a case I handled back when I was at the New York AG's office doing similar cases as I do now, but under a much more pleasant burden of proof, I got to say. So, and that was basically what it seemed to be. Well, what happened was people who were subscribers to a Prozac.com email service from the Prozac.com website, Eli Lilly was going to shut the site down, and so Eli Lilly politely sent them a note saying, we won't be offering this service, because you could get reminders to walk your dog or fill your medication. And from what I understand, the program that was supposed to send out those emails was supposed to say, fetch an email address, send it. Fetch email address, send. But instead it went fetch, 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 and then send. And so every single person subscribing to a service that would be considered somewhat sensitive, given that it was the Prozac.com website, saw all of each other's email addresses. And it probably was, a kind of, I didn't check my work. But I will promise you something. If there is a change to a home page of any money-making website, especially one that's publicly traded, every pixel on that page is agonizingly analyzed before anything is put into production. But if it comes to the users, if it comes to making money, the stand, if it's a matter of shareholder value or quarterly returns, you got to get it to market. And I know I'm not trying to be un-American. I know that we want to be capitalist, but part of capitalism is, not to use a Marxian term, a dialectic of opposing forces, and those forces should be consumers, and consumers cannot oppose and create a better product unless they're informed. DoubleClick lives on. This is a case of ours from last year. And the judge cited the DoubleClick decision. I'm just going to read this aloud. I know you can read it, but the collection of demographic information does not constitute damage to consumers. Advertising on the internet is no different from advertising on television or in newspapers. I will pause there. Okay. Even if the plaintiff took steps to prevent the data collection, her injury is still insufficient to meet the statutory threshold. What does that mean? Your data has tremendous value. Your data has tremendous value when it's sold to data brokers by a third party. But generally speaking, unless there's statutory damages, under the law, under many laws, unless you are literally out of pocket, unless you lost money, unless you economically suffered, you have no loss. And you will find some big companies that have an important consumer image, and if you look on the first page of their papers, they're not going to put it in their ads on their website. They say, our web visitors' data is valueless to them. It is worthless. They cannot expect us to think that it has any value whatsoever. It only has value to us, and we are entitled to buy and sell it as we please. All right, to wind up, there are some exceptions, but it leaves some big gaps. So, for instance, there's a California decision called Kwikset, and under Kwikset, one analogy used by the court is a blood diamond, or made in America, right? If I buy a product that I expect to have certain intangible characteristics, like I do not want to buy my fiancé an engagement ring that is a blood diamond, and it turns out that it is, perhaps the intrinsic value of the stone itself may be unchanged, but in fact it is worth less. I paid for something else. If I paid for something that was to be made in America and it in fact is not and is falsely labeled, then it is something else, and perhaps I've suffered an economic loss. But that means you have to have paid for it. So if you're going to a free website, that gets tough. Now you will see in some of our cases, such as against HTC recently, that settled HTC and AccuWeather, as well as a case we currently have against Apple for the iPhones for GPS tracking, GPS tracking is a battery hog. It takes a lot of resources. If you look in your user manual, it says to conserve battery, turn your GPS lower. So, off, anyway. So there you actually have an argument that there's a diminution of value in a physical resource that's part of the value of the phone. That's not the way we want to be handling consumers' ability to enforce their rights on the web. So I'm going to, did I get a zero? Is it zero now? Okay, you're very kind. Look, I heard a story that scared me, and that was that there was a New Zealand town that installed surveillance cameras, and they took a citizen's vote on it. The citizens were fine. But then the surveillance camera company came out with software that added biometric identification, and the police department upgraded, but they didn't put it to a citizen's vote. So we're moving into a world that's different. And if you want to think about legal regimes, well, it has to be a combination of them. I think state AGs have an important role to play here because of their burden of proof and their ability to embrace addressing of harms for many of their citizens, especially if they have unfairness jurisdiction, which doesn't exist in New York, even though it has a baby FTC statute. I will just quickly say that I am an advocate for using torts. Our torts need to be living and expanding to embrace the fact that there's a huge volume of data. We have railroad trains running through our heads and through our computers and through our homes. And so the right of publicity may not mean you're a movie star and your image is taken. Or intellectual property may not mean that you're somebody who's actually developing something that is a traditional trade secret, but nonetheless that you keep confidential, and maybe the value that you attribute to it is the value not to have it taken without your permission. I think trespass lives on in these cases, particularly in terms of installing technology on your computer that tracks you. And I would be delighted to see privacy treated as a fundamental right. And who knows, the provocative thing I was going to say is maybe the technology will shift and a company will come along that will be in a position to be a data intermediary, ombudsperson, and perhaps negotiate for the consumer to obtain value for that data, and then we'll see a switch, and the money will still be made. It just might be realigned differently, and consumers would be able to recognize value and, more importantly, control it and safeguard their privacy. One quick comment I will make, in terms of domestic violence, there is an organization called Safety Net. It's part of the National Network to End Domestic Violence. They recently were recipient of some cypre money in a settlement we had. And one thing that they do is they train primarily women to be safe on the internet, to do things to their computers to keep them safe, and they train shelters to avoid getting hacked and to avoid having the clients at those shelters tracked. And I met with some people there. It looked to me like they did a very important work. And so I would just like to second the sentiment that that is a paradigm well worth keeping in mind, not to mention the fact that if you live in a foreign country and someone tracks your location, then instead of getting an ad, you could die if you're involved in a protest. And I think that's happened. So we are talking about life and liberty, and I think those are important values, and I would like to see them, some extrapolation to recognize that that's what's at stake here. I have many more comments, but maybe next time. I really appreciate the chance to be here.
Professor Henry Perritt is our final speaker. He graciously agreed to be the last speaker on a Friday afternoon. I guarantee he is well worth the wait. He's extraordinary. He's written more than 75 law review articles and 17 books, so I'm no longer proud. But one thing that distinguishes him is the immense common sense. So let me let him give you some of that.
Thank you, Richard. I want to build on three things that you've heard from Mr. Stampley and Professor Kim. You remember Mr. Stampley said he grabbed my hand when he was telling you the story of reflectively getting ready to sign the guest book at the Russian consulate when they were visiting. The second thing also came from Mr. Stampley toward the end of his presentation when he said, I didn't check my work, referring to a internet enterprise that made a mistake and let some data escape. And the third thing that I want to build on is Professor Kim's theme that tort law can provide a remedy. My sense is, and I've developed these ideas and these arguments in somewhat more detail in the paper in your materials, my sense is that much of the discussion, not necessarily at this conference, but much of the public discussion about this focuses on the wrong boogeyman. In my view, the problem is not so much behavioral advertising as it is other things. I mean, I use the internet a lot. My tastes and what I like may be quite different from yours, but frankly, I much prefer the little ads that pop up in a Google search or when I'm on Facebook that talk about sailing or flying or theater, things that I'm interested in. I much prefer those to the Chevy ad that increasingly pops up and makes me watch it for 30 seconds before I get to see some sportscast that's been linked to by a news report. And so I'm unmoved by a lot of the concern about behavioral advertising. Frankly, I think that will make our lives better and will certainly make markets work more efficiently. So I want to try to persuade you that other boogeymans are more worthy of concern. And I also think that many of the solutions that people talk about, certainly the solutions that have got the furthest in the United States Congress, make the real problems worse. Now, I think it's common ground for all of us that as technology changes, Mr. Stampley showed you the pictures of early railroad technology. It's common ground for all of us that as technology changes, the risks change. And frequently things that we didn't perceive as risks at all loom large in importance. And that surely is true with digital computer technology and digital computer networking technologies. It makes it possible to get more stuff about us. Makes it possible for there to be more ways to connect the stuff about us so that more and more complete profiles about us are available somewhere out there in the cloud. You've heard a lot about that today. It makes it easier to exchange it so that there can be market transactions of these complete profiles about us. And I think it makes it easier to get the technology changes much more recently, make it easier to get into our souls, if I can put it that way. Think about, if you do very many Google searches, think about what those patterns of Google searches, which are certainly available to Google. Now, I'd have no way to know how much they keep and what they do with it, but it's certainly possible for them to keep all of it. Think what that profile of your Google searches shows about you. I mean, it's not only like someone followed you around and found out what books you checked out of the library, it's like they followed you around to the carrel in the library and looked over your shoulder as you read and thought about and knew what pages as you skimmed through a book, or what pictures you looked at if you just went to the book and looked at the pictures and not the text. It is enormously revealing. And likewise, we've heard a lot about geolocation data. That also reveals quite a lot about us. And now that facial recognition is improved, it's very difficult to be anonymous. I think that's kind of the frontier of where this is going next. So it's certainly true that the risks are greater and the risks are different than what we've seen before. And the risk, I think, is to our personal autonomy and to our individuality. But some of the things that we have assumed that represent the foundations for the way the legal system has responded are increasingly obsolete. For one thing, and this is the second of 7 points I want to make in my presentation, traffic analysis, what the intelligence community calls traffic analysis, or what some people call transactional information, is now, in my view, more dangerous than access to content. And if you look at the legal regime, if you look at the Wiretap Act and the Stored Communications Act and the Pen Trap Act and FISA, the Foreign Intelligence Surveillance Act, all of them impose greater legal barriers to access to content than they do for access to transactional information. And yet the click tracks of your Google searches are transactional information. There's some argument about that at the margins, but basically it's treated as transactional information, not content. And it's quite easy for the Federal Bureau of Investigation or the NSA or the, much scarier in my opinion, for the DeKalb County State's Attorney's Office or Sheriff's Department to get hold of that information than it is for them to tap a telephone call and find out the content of one telephone call. Well, I would submit to you that this enormous volume of transactional information is poses far more risk to your autonomy and your individual liberty than tapping one telephone conversation does. Secondly, the biggest disasters that might befall us come not from some scheme that DoubleClick cooks up to extract a few more pennies for some ads. The disaster that might befall us is some cyber terrorist, whether state-based or otherwise, brings down our financial system. Imagine what it would be like if all of us waked up one morning or just going home in the afternoon, if we went to our ATM and our account balance was zero. And then you call up Citibank or Chase, you know what it's like to try to get a human being anyway. And if you finally get a human being, they say, no, you've never had an account with us. Imagine what that would be like. I mean, I would submit to you that would be a far worse catastrophe for the United States than a dozen nuclear attacks on major cities, because it would bring down the whole way in which we interact with each other over the whole country. Now, it is believed that the networks, that the financial services industry networks are highly secure, that they're the most secure anywhere. That may be right. But I do know that the regulatory regime for those networks is essentially based on self-policing, just like much of the regulation of derivatives was based, and much of the way people kept track of paper for mortgages in case a foreclosure might be necessary. That really, really worries me. And so I think the huge threat that we need to protect against is a cyber terrorism threat, a kind of data breaches on a smaller scale. It's the data breach problem, much more than the misuse of data for marketing purposes. Now, the fourth point I want to make is that a much greater threat to our individual liberty the catastrophe is from the cyber terrorism. But on a day-to-day basis, the greater threat is from government surveillance, not from commercial misuse. We are, and that comes back to Mr. Stampley's point of his father grabbing his hand, because you never know who's going to see that name. I had one of my better students in a seminar that I'm teaching in nation building. He's really a very good student. And he's doing his seminar paper on the Muslim Brotherhood, certain aspects of how it attained political party status. And so he told me the other day that he had seen reference to a very good Muslim Brotherhood website, but that he was afraid to go to it. And I said, why are you afraid to go to it? And he said, well, you never know who might be watching. Well, if we all come to think that way, it doesn't matter who's watching. The mere fact that we think they might be watching is enough to cause us to behave like we were living in Stalin's era instead of the United States. And not only that, I'm going to exaggerate a little bit to make the point, almost everything is a crime now. I mean, all of us, how many of you really seriously consider whether you are this side or that side of the criminal threshold if you look at some racy material on the web? How many of you consider whether you're violating the interstate gambling laws if you place a bet on a football pool? And how many of us are absolutely meticulous about never doing anything that might infringe copyright or that might compromise some kind of a copyright protection scheme? All those things are crimes. And if the government has profiles of all of us and can do pattern matching for people that might be interesting and target somebody like my student, they can ruin their lives. Because even if the court system, as one would hope, in the end says you didn't do anything, you can't be convicted of a crime, it would ruin any of us to be the targets of a criminal prosecution of terrorism, pornography, gambling, any of that stuff. And the way that it may be that the Federal Bureau of Investigation, the National Security Agency, are very professional and high-minded. The FBI hasn't always been so. But the thousands of county prosecutors and municipal police departments damn well aren't. And we don't want them getting into our click track information that Google has, because no end of trouble will come from that. Now, here's the problem. One problem I've already talked to you about, and that is that the existing legal regime under the Wiretap Act, the Stored Communications Act, the Pen Trap Act, and the Foreign Intelligence Surveillance Act places a higher protection on content than it does transactional information and this pattern matching stuff, while I have been arguing that it's the pattern matching that poses far more dangers to us. So I think that there needs to be some development even within the existing legal regime that would ratchet up the kinds of surveillance that require some kind of judicial intervention without trying to fine-tune in a short presentation this afternoon when probable cause ought to be required and that sort of thing. And then we need to be very conscious of the proposals that are moving through the Congress that are justified on the grounds of protecting cybersecurity. The House bill, CISPA, which actually passed the House and died in the Senate, and CISPA, in case you're interested, stands for Cyber Intelligence Sharing and Protection Act. CISPA, I think, particularly takes the wrong approach, because what it does is it makes it really, really easy for data custodians in the private sector to share information with the government, almost any part of the government. And it purports to place some restrictions on what the government can use the information for, but guess what isn't restricted? At one point, until very late in the game in the House, information related to intellectual property infringement, information related to very broad definitions of pornography, including, quote, depictions of sexual conduct, end quote. All of that is treated as national security cyber terrorism stuff that the government could do with as they wish. Not quite as they wish, but in a very unrestricted way. And then, as if that's not enough, CISPA granted extremely broad immunity to the private sector data custodians, so that if they let the stuff, if they gave it to somebody they shouldn't have given it to, if they let it get out, if they didn't check their work, well, tough luck, folks. No liability in civil or criminal court, state or federal. Now, the Lieberman bill, the Senate bill that the administration preferred, took a different approach. In fact, it really was quite stark. I've looked at a lot of legislation in my career, and usually you get the House bill and the Senate bill, and they at least have similar structures, and then you kind of look for the detailed differences. These two bills had completely different structures. The Lieberman bill focused first on development of standards, of security standards on a public-private voluntary basis, and it was quite an elaborate bureaucracy to help do this. And then it also granted some immunities, but the immunities were more limited. That if a private sector data custodian followed the standards developed through this process, then they would be liable only if they were shown to be grossly negligent. So by implication, ordinary negligence would leave. If they didn't follow the standards, then they might be liable for ordinary negligence. So here's what I think we ought to do. First of all, we ought to continue to talk about the geo-tracking and the private sector advertising and all that kind of stuff, because though I say those are not the most important concerns, they raise legitimate concerns that I think we should have continued debate about. But I think the most important thing is to make sure that we keep the warrant requirement and that we expand the requirement for judicial intervention before governments at any levels can get into this astounding store of information about our lives and our souls. And secondly, the law ought to say, the law already says this, has for a long, long time. I mean, Anglo-American law is amazing for its flexibility and adaptability. The law ought to say, if you didn't check your work, to use Mr. Stampley's phrase, you ought to have to pay the price. And negligence is an extremely good system for doing that. It's very decentralized. It doesn't depend on some government bureaucracy to guess what things are going to be like. It says that the people who participate in the marketplace are responsible for being mindful of risks that they are best positioned to understand. And then they are also responsible for taking precautions to reduce those risks, which they also are best positioned to understand and to cost out. And if they don't do that, then they have to pay the cost of injury that results from that breach of duty to prevent foreseeable risk. Now that seems to me like a really, really good system to help protect us against cyber terrorism and the data breaches. Because if Chase Bank is not checking its work, then Chase Bank ought to be liable if somebody gets into my bank account and zeroes out the balance. The problem is Chase Bank, and I love Chase, it's my banker, they do a great job for the most part, so I'm just using them as an example. The problem is that if that happened today, Chase Bank probably wouldn't be liable because of the economic loss rule in negligence, which says that absent some exceptional categories, you can't recover in negligence unless there's been some kind of physical damage. And therefore, mere economic loss is not enough. Now, there are enough exceptions. There's enough commentary that raises doubts about the viability of the economic loss rule, which mainly is intended to create a bright line boundary between breach of contract liability and tort liability, that there is ample flexibility for the common law to evolve to make data custodians liable for failing to adhere to best security practices. And if the courts aren't bold enough, the state legislatures can start writing some statutes that would do that. And I think that would buy us a lot more cybersecurity than an awful lot of other stuff that's been talked about. Thanks.
Questions for the panel?
There's one danger that I don't think anyone's brought up today. I read an article in Newsweek, I think it was July 16, 2012, of actual physical changes associated with internet use that mimic those of cocaine use. And that would mean that our surveillance issue would be compounded by the fact that we'd be representing ourselves as altered beings, and then the surveillance would be of us as the altered beings that use of the internet produces. I hope I haven't overstated the findings in the article, but
I don't know, but I just jotted down the reference so I could go read that. But
I thought Professor Kim was kind of getting into those issues.
It's interesting you say that because I've recently implemented a no laptop policy in my classrooms, and I've explained to them, because I used to take a very sort of libertarian approach, you're responsible for your own education. But after hearing, I didn't hear about this specific, comparing it to cocaine use, but I do know there's an addictive quality to, you get the little dopamine squirt, when you check your email or get a status ping. And so I told them, I used to think you were able to control yourselves, and so I would blame you if you weren't paying attention, but now I realize it's not really your fault in a way. So I'm going to take that control away from you because you're basically addicts.
Good for you.
You're addicted to this little product, and they just don't realize it. They get sucked in a little by little, and then they're hooked. And, frankly, I'm probably one of the 2 people, or maybe the only one in this room, who doesn't have a smartphone. And part of the reason is because I know I would obsessively be checking my, texts and email. And I do think we need to acknowledge that there are addictive qualities and not sort of laugh and say, oh, I can control it, because I really do think there is, and the science has shown there is something to that.
Yes. Thank you.
I would validate what the lady down front just said. It has. I'm not a scientist, but I have read that there are neurological changes in our brain for whatever we do, including checking our email and so on and so forth. But I also wanted to follow up and just note that Professor Perritt said, well, it's as if somebody were looking over your shoulder in your carrel, watching what you read. Well, actually, that's exactly true, because if you have a Kindle, or I assume any other e-reader, and you highlight or you take notes, which those applications permit you to do, all that information does go back to Kindle, which I personally view as rather creepy, although I have an e-reader myself and I use it. So.
Hi, I wanted to go back to really where the seminar started this morning about geo-tracking and sort of what the general standards are. And I agree that it's time to really look at the whole third-party doctrine, because fundamentally what I think is wrong with where the Supreme Court started going wrong as late back as the 80s with those beeper cases is that what makes us upset about this technology is that what was upsetting Mr. Katz when he was in the phone booth on that phone call is that he was in the phone booth thinking that he was taking steps to protect himself. He had a reasonable expectation of privacy against people who were not there. And I think that that really is the rule around which we should measure this. That is, we as a society should have a reasonable expectation of privacy from people who are not there.
Now, I agree, and I certainly understood Professor Perritt's point that I was talking about the commercial world, and I certainly take the point about government surveillance being of concern. However, the government and GM have kind of gotten married in this case because there is a great deal of information collection by the government through these entities, and I have not dealt with a Fourth Amendment case in years to know that if you could translate a Fourth Amendment application to the actions of a commercial entity that has an agreement with the government to provide certain data.
Well, first of all, I completely agree with you that the Smith case, the idea that if you disclose it to a third party that you've lost your reasonable expectation of privacy, I think that is ready for the dustbin. And I think what's encouraging is that Justice Sotomayor seems to agree with that, because that was the gist of her, at least if I'm remembering who wrote which concurring opinion, it was the gist of her concurring opinion in the very recent Jones case about the tracking device on the automobile. Now, so I agree with you that the reasonable expectation of privacy should extend to third parties, whether they have it by some kind of implied consent or not. Now, the question of mapping the Fourth Amendment into liability for private sector entities, I think, is.
I was probably just being hopeful. I should say that.
Yeah, I mean, I think that's difficult. I think about that a lot in the employment area. Not so much Fourth Amendment as First Amendment there. And there are a lot of theories that I, as a law professor, think are really nifty, interesting theories to say that that what we wouldn't think of as state action ought to be treated like state action, but the courts don't buy most of those theories.
Yeah.
Just a point that we talked about the cyber attack against the banks that happened last week. Supposedly the source was Iran. Now for me it was just an inconvenience, but it was an inconvenience where I couldn't access my account just for a brief period of time. But I literally couldn't, if it happened or it was extended, I wouldn't have been able to transfer money from one account to another. My transactions of the day, so it's future is here.
Absolutely. And the kind of attack that occurred the other day, based on the news reports, was what's called a denial of service attack, which is particularly easy to launch, and they've been well understood for a couple of decades.
And the effect is devastating to...
Yeah, it can be devastating because it shuts down, it basically blocks the connection to the internet, and the bank's response, at least as quoted in the press, was, "Oh wow, we didn't expect that this would ever be so big." And basically, the defense is you just make your thing, your router or your server, too big. It's like if you fear congestion in a hallway, you just make the hallway bigger. And so the notion that they wouldn't even have done a very good job of sizing potential congestion attacks is a little scary. And the other kind of thing there are all kinds of technologies that can be used, and I wrote about a couple of examples in my paper, that can be used to get inside a network and start manipulating the data. And I think that much greater damage could result in that kind of thing. And the problem, one problem is that the attackers, there's an ongoing competition between the attackers and the defenders. But the other problem is that there are many potential attacks that are extremely well understood in the computer science industry that even some very large enterprises have not embraced because it's too much trouble.
Well, may I add to that and echo the tie-in to my check your work comment? I used to work as general counsel and also part-time consultant for a company here in Chicago called NeoHapsis, which deep tech guys investigation, and just based on their work and studies, a lot of intrusions, very serious ones, are a result of not applying routine. You know how you get a notice saying update your software? It's a result of not doing that at the enterprise server level. That is one of the most major causes, leaving an already known vulnerability available for intrusion when a patch is available to fix it. So.